Every day in the USA, people find themselves in court.
Good afternoon, Mr. Hunt. You're Jeffrey Michael Hunt.
Yes, sir.
Of course, I know you, but I need to identify you for the record. You're here with your attorney, Mr. Ross Truckee. Is that correct?
Yes, sir.
Also present is prosecuting attorney Deborah Davis and that Officer Willie from the Three Rivers Police Department.
Officer Miley.
What's that?
Miley?
Miley, I'm sorry. Sorry about that. I'm
I'll
trying
get
to read,
used to it.
trying to read your
I thought it was Kelly.
so Officer Miley, the complaining witness in the complaint is Anthony Fuller, but also present, your uncle is here. I've been talking with him, and your housemates are here. And we were ready to put on a preliminary examination. The file number here, if I didn't recite it, is 25324FY. Let me go through what the charges were. It's alleged that on or about February 23rd in the city of Three Rivers, you did possess methamphetamine. That's a felony punishable by up to 10 years imprisonment and a fine of up to $15,000. You're charged with assault and battery upon Carrie Yerrick, one of your roommates, as a third offense, which is a 5-year felony, punishable by up to 5 years and a fine of up to $5,000. Count 3 is a domestic assault upon Naomi Fulton, also a resident of that house on Pleasant Street. You're also charged with assault with a dangerous weapon, a knife, on Carrie Yerrick, which is a felony punishable by up to 4 years imprisonment. And count 6 is assault with a knife on Naomi Fulton. Although I thought that was a log, but anyway, a knife. As a third habitual offender, all of this as a fourth habitual offender, which theoretically would make the possession of methamphetamine punishable by up to life imprisonment. This is the time and date scheduled for a preliminary examination in this matter. I'm sure Mr. Truckee recited this to you. In fact, I heard him going over here again. I explained to the complainants and to your uncle that a preliminary examination is a hearing where it must be established that probable cause exists, that a crime was committed, and probable cause that you did it. You have a right to have a hearing. You also have a right to waive it if you wish. And that's what I see here. You signed a waiver of preliminary examination. Let me read that to you and make sure that that's what you wish to do. I, Jeffrey Michael Hunt, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. Mr. Truckee has been appointed to represent you. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with the crime. Here's the operative language. I voluntarily waive my right to a preliminary examination. I understand that I will be bound over to the circuit court on the charges in the complaint and warrant. Is that your signature on here? And that's what you wish to do?
Yes.
All right. Once I sign this, I lose jurisdiction over the matter and it goes to circuit court. It'll be heard by Judge Stutzman. Your bond in this matter was denied by the magistrate. Let's take a look. That's an unusual step. Theoretically, when there is no bond, the prosecutor is under an obligation to bring the case to trial within 90 days. You've been in jail now for about 12, I think. Let's look at the bond. Mr. Truckee, I understand you wanted to address the issue of bond.
Yes, Your Honor. Well,
First off, bond was denied in this case, and that is an extraordinary measure meant to protect society at large. And in this case, I just asked the court to consider the relevant factors. We would admit that there's a prior criminal record. I don't have evidence, and I don't know what the magistrate had based on court records for failure to appear or non-appearance. I don't believe there's been any history of actual flight to avoid the prosecution of a crime. Defendant has significant ties to the community. His uncle's here today. I believe he's got a couple other relatives that live in Three Rivers. He's been here the bulk of his life. He's financially without means to leave at any great distance. I don't believe he owns an automobile, nor a passport for that matter. This incident was localized to the living situation at the venue, alleged, not at public, not at a school, not at a park, not strangers. The most serious charge, the charge of carrying the most significant penalty, is a possession of methamphetamine charge, which is not necessarily the type of crime that provides further danger to the public. I believe there are community members that would assist in ensuring Mr. Hunt's appearance if he were to post bond. There are also pretrial release opportunities available that could ensure his appearance, including GPS tethering and things of that nature. So we would ask the court to review the relevant factors. And also, I would state there's an absence of threats. There's alleged conduct that is threatening, but I don't have any information before me that states that he's made any statements that he would seek retribution or go back and do this, that, or the other thing. Mr. Hunt would like to be able to have a bond. So I'd ask the court to, his dog was left at the home, the venue. That's very important to Mr. Hunt. He'd like to make sure that he can do what he can to look after that. He states that that's his only real tie to keep himself here on earth is the love of that dog. So ask the court to consider those factors, review the facts before it, and make a just decision regarding pretrial release.
Ms. Davis, you have a response?
Yes, Your Honor. Mr. Hunt has quite a significant criminal history. I believe there's 8 different domestic violence related charges, convictions. He also has a felony conviction for tampering with an electronic monitoring device that he pled guilty to in 2017. The concern with that being that if he is to be afforded some sort of bond, we would be asking for a GPS tether to keep track of him because he is homeless. That's why he was staying at the Yerricks for the couple of months. However, if he's got a prior history of tampering with an electronic device, that doesn't give me a whole lot of confidence that he's going to leave this one alone. It's my understanding there are different variations of them, and this list could have a I forget what she calls it, like basically one that's harder to cut through, but it's still not probably impossible to get it off, obviously. So there's a concern about that. Other concerns, specifically, he's got some significant mental health and substance abuse issues. He, according to Officer Fuller, said when they were trying to take him into custody in a room full of weapons, that they would have to shoot him because a taser wouldn't work. So certainly he's got some significant behavioral issues, and I'm concerned for the safety of the public that if he's out and he doesn't have anywhere to go, that he's required to have some accountability and stay there, he could end up anywhere in this county or otherwise. And that's great that he's got family support, but being out on bond, the danger to the public that we have here, the risk for him to not appear, the risk of him using methamphetamine again and having these hallucinations, calling people witches and demons, this is a very dangerous situation. The weight and sufficiency of the evidence can be addressed by the court in these. And I would ask the court to consider that, because these victims are ready, willing, and able to testify. We have lab results from the methamphetamine. Methamphetamine is shockingly the most serious charge, even though there are these other serious domestic violence incidents. And with his record, he is likely going to prison. And the methamphetamine, as I said, we have a lab result. It was found in his possession in his room, as I recall. So it's a matter of time, and it's like pay me now or pay me later. He's not working that we know of, doesn't have anywhere to stay, has a history of violence, has significant violent behaviors in this particular case, and we are prepared to go forward within 90 days. And we'll go from there. Thank you, Your Honor.
Thank you. Mr. Hunt, it is unusual to actually deny bond. General rule is people are entitled to a bond. The fact of the matter here is probably any bond is higher than what you can make. You don't have anywhere to go. The place where you were living is where all this went down, and the people that were there, Mr. Yerrick, Ms. Yerrick, her mother, Naomi, are the complaining witnesses in this case. So you can't go back to where you were living. This was some sort of a mental health or methamphetamine induced incident.
No, it wasn't.
Well, maybe not. But the bond information sheet says there were these other things that happened, and they came, and you were found hiding behind a chair surrounded by weapons.
I wasn't hiding. There's no weapons except the knife.
2 axes, a
That's a
9.5-inch double-edged dagger, a
That's the
katana.
That's a rep.
This
that's a
is
team
not
weapon.
going to end well. He repeatedly asked the officers to shoot him,
Correct.
and that's not good. That's really why they denied the bond. I don't want the officers to shoot you. I want you to get squared away. So I could set a high bond, like $100,000, and it's unlikely that you would post it. It's more honest to just deny it. You'll have another crack at it in circuit court, but it's almost an insult for me to say, all right, I'm gonna give you a bond. Here's a $100,000 bond that I know you can't post anyway. So all the issues, you tampered with a tether before, you have multiple previous domestic violence convictions. I didn't know there were 8, but there's certainly at least 2 previous ones.
I don't have 8. I have 7.
I don't think you have 8
Oh, I'm
either.
sorry,
I think
7. There were some that were dismissed or pled
All
down,
right.
but he
I didn't
said
cut my
7.
tether out either. Died.
there were threats to the police and offers to do a suicide by cop and everything else you disagreed with, but you agreed with that one. I don't want you to get out, harm yourself or someone else. So the motion to reduce the bond is denied. You can address it again in circuit court. That may move this case to resolution faster than it would otherwise, because they're gonna have to do something within about the next 80 days. All right, you're good to go with the officers. I don't wish you any ill, but
you, Your
I
Honor.
don't want you to harm yourself or anyone else.
Thank you.
Thank you. Deborah, did you sign that waiver? Yes, you did.
I did.
All right, do you need a copy of it?
Yeah, I think that.
David would never give it to me. He'd want to go do what he was gonna do with it first, but I will use it and I'll make sure you get a copy for your
Yeah,
records.
I know Diana probably wants to have one to process on our end. so-
And I'll do an order for the circuit court showing that I deny the motion to reduce bond.
Thank you, Your Honor.
All right, the next step is the matter goes to circuit court. And something's gonna have to happen within 90 days, or they have to give them a bond. So that may keep the case moving more quickly than it would otherwise. Thank you all for being here.
Will I be notified if he's released?
Yeah, well, he's not gonna be released, but yes,
Actually, that does bring up, they had mentioned before. He's not on bond, so there's not a no contact. We've had these issues from the jail before. He has not, to their knowledge, tried to contact them, and I haven't checked jail records to confirm that. But if it does become an issue, I'll be asking for a protective order so that
all right, there is a no contact provision as part of the bond.
it's just they won't enforce it at the jail unless that they identify it as a protective order, whether he's in custody.
Well, you may have seen that recently happen with that case in
Yeah.
Oakland County where the mother was trying to contact the caregiver of those children. The Oakland County prosecutors filed a motion to restrict her communication privileges.
Yes.
All right, well, he hasn't done anything so far. If he does, you can bring the action in circuit court.
Very good. Thank you, Your Honor.
Thank you.
Thank you.